Good morning. I think we'll go ahead and get started this morning. Want to respect your time and making sure you can get back to the office to get to work. Thanks for joining us today. It's been a number of years since we've done this in person. I think the last time might have been 2019, and we had that COVID thing for a couple years. And now we're back in person. This is actually my second in-person presentation I've done, so I'm still feeling a little rusty. I'm still used to the Zoom presentations. But fortunately now I get to move around because I always hated being stuck in front of my camera. So just to segue in, as we're talking about COVID, let's just jump right into this and talk about returning to the office. As many of you have taken note, more and more companies are requiring their employees to return to the office. How many of you still have employees who are working remotely? Quite a number of you. I was talking to somebody who happens to, used to work out of Lancaster and now works out of Vermont. Lucky. And there's a lot of advantages to having employees work remotely. I really enjoy the opportunity to, dig into a day of work on the couch in my sweatpants. I'm not going to lie. My kids used to joke with me when I was working from home remotely all the time because sometimes I'd come out and I'd literally be wearing a suit, coat, and sweatpants or shorts, and they'd be like, "Zoom call, Dad?" But there is something really important, I think, also about getting people back to work. And it depends on the office. It depends on the work. It depends on the position. It depends on the employee. How long has that employee been with you? Do they know how to do their job? Talking about my own experience, I have paralegals who have been with the firm longer than I have. They know what they're doing. They don't need me to supervise what they're doing. In fact, sometimes they need to supervise me. And so, allowing them that opportunity to work from home when they want to is great for them. And it's also really important that they're in the office from time to time, just so we have that camaraderie. We're building that team mentality. So there's both of those going on, and it's a balancing, I think. There are, some legal considerations about requiring people to return to the office. But keep in mind that an employer has an absolute right to require its employees to return to the office. So if you are in a position now where you're saying, hey, this isn't working, it may be time to reconsider your policies. And you're going to hear me use that word quite a bit throughout today, policies. And I think that policies are very important because it sets the expectations. It communicates the expectations. It provides justification for the decisions you're making. So as we're talking through this, talking about policies, I think it's important that you keep that in mind. That you're having policies that are uniform, that they apply to similarly situated employees in a uniform manner. Similarly situated employees being employees who maybe work in one department together. So maybe I'm treating all my paralegals in one sense, but obviously my receptionist has to be in the office because the nature of the position. We can't have a remote receptionist. That doesn't really work so well. So you're looking at the nature of the position, you're looking at the nature of what your expectations are, and then you're also gauging the productivity of that employee. And keeping in mind that, working remotely is a privilege in many cases. And productivity is the important factor here. So if you have an employee who's not meeting your productivity standards, it may be because they're working remotely, it may be because they need extra coaching, it may be because they need hands-on, it may be because their kids are running in and out of the office/dining room table. And so you can always, gauge the productivity, and again, requiring those employees, to either come back into the office or reframing your expectations as to what productivity is expected while you're working remotely. Now, one of those legal considerations is work from home as a disability accommodation. And that's not just as to COVID, but I've heard this come up a number of times, and I wanted to address this, is employers are coming to me and saying, we have an employee who wants to work from home because of a diagnosis, a disability, they just had surgery on their leg, they're not mobile, but we don't want them to work from home. And, it sort of raises some of the questions of, well, you were able to accommodate this during the COVID pandemic. Is there a reason why you can't accommodate it now? Because as we look at reasonable accommodations under the ADA, it is a reasonable accommodation that allows the employee to perform the essential functions of their job. Essential function of the job being productive. So if an employee is not able to be productive, again, that's not a reasonable accommodation. But keeping that in mind as you're looking at that, whether that is, related to COVID or other disabilities, reasonable accommodation could be working from home. We're going to talk a little bit throughout this presentation about the Pregnancy Discrimination Act and that implications as well, that you're treating pregnant employees in a similar fashion as you are treating all other employees. But we'll get to that in a bit. Some of the additional considerations are going to be employee morale. As I said, I really like working from home from time to time. I also really like being with my coworkers in the office. I remember one time during the pandemic, I had been working from home for weeks on end, and I just was at a dead end in the day, and I just was not getting anything done. And I realized I needed to go into the office and make some copies and do a few things. So I was like, all right, I'll run into the office. And I go in, and there's maybe 15 people in the office. It was pretty, we had a pretty, sparse setup at that time. But I started talking to various coworkers, and I spent 10 minutes talking to this person and 10 minutes talking to this person. And when I left, I felt intoxicated. I mean, I literally, my head was buzzing. And I was like, oh, that's called serotonin. That's, the interaction with people. It's important. And to have that, was really important. So the employee morale, it goes both ways. And I think that's important to balance that. As I talked about, productivity, remote work is a privilege. Lack of productivity results in the loss of privilege. Employee mentoring and opportunities for growth. And then again, as we're considering the job duties, interactions with customers, clients, vendors, the tenure with the organization, the need for engagement with other team members. And I would say Zoom does not provide engagement. I mean, we are all sick and tired of Zoom. And an interesting note, guess who's requiring employees to come back to work? Zoom. I think it's 3 days a week now. They're saying, hey, you got to be in the office. So clearly they're also aware that, that does not work for employee engagement. And as I mentioned, I believe that anything employment related is, rooted in communication and documentation. That you're communicating your expectations, and this is, with respect to, specifically as to working remotely, but anything that you're doing with your employees, communicating those expectations is important. And then documenting the results, documenting where that employee is meeting those expectations and where that employee is not meeting those expectations, and letting the employee know when they're meeting expectations and when they're not. Because oftentimes you have employees who are out there, they don't know. They don't know that you're dissatisfied with their performance, or they don't know that, hey, you're knocking it out of the ballpark every night like the Phillies were doing last night. Let's go. So sick employees. When we talk about, sick employees, and I think this is on our radar, we're going into the fall season. We're not just talking about COVID now, just talking generally. Employers should have a uniform policy providing that when an employee is sick, they have a fever, they're coughing, they have whatever, form of malaria or whatever they brought from their children's preschool to the office. Like, stay at home. And I think communicating that, I think we're much more in tune with this these days. And used to be, people would show up to work and they'd toughen it out, and particularly some of the old guard at my firm, they'd show up and they'd be, white as a sheet and running a fever and, but they're here because, by golly, you work. Well, no, you don't, because I don't want to get whatever you've got. So, I think it's important that you're communicating that to your employees. And again, I would say having a policy in place that says, if you're sick, don't come to work. And, that ultimately, there's going to be disciplinary action if you're showing up to work and you have a fever and you're sick, because that ultimately can affect the entire workplace. Also, just as a note here, requiring doctor's notes following a set number of days off. Generally, we're looking at 3 to 4 days. If an employee's out of work, you're going to want to know, 1, were they actually, sick, and 2, that they're able to return to work. And for those of you with more than 50 employees, keeping in mind that an employee who's out for more than 3 days, that becomes FMLA qualifying. And so you're going to want to keep track of that as well. The EEOC has issued some enforcement guidelines recently, and one of those is long COVID may be a disability under the ADA. I think that the ADA is very expansive, and the Americans with Disability Act, that is very expansive and provides for a lot of coverage. So it's no surprise that the EEOC is considering long COVID to be a disability, but something to keep in mind. So we can, spend all day talking about COVID, but we're not, I promise. I think this might be the last slide related to COVID. And instead, we're going to go into the very hot topic of the Supreme Court's recent decision on affirmative action. And what are the implications of the Supreme Court's decision for affirmative action in the college admission process and employers? As you probably know, earlier this year, the Supreme Court ruled against, I believe it was Harvard and the University of North Carolina, and effectively eliminated the use of affirmative action in college admissions. And while that ruling did not address the efforts of employers to foster a diverse and inclusive workforce, it did provide that colleges cannot use race as a factor when determining admissions. And this will have implications for employers. So the EEOC came out with a statement about this, and the EEOC said that it remains lawful for employers to implement diversity, equity, inclusion, and accessibility programs that seek to ensure workers of all backgrounds are afforded equal opportunities in the workplace. So that's the EEOC's position on this. As Title VII provides, employers must provide equal employment without regard to race, religion, gender, sexual orientation, any other protected classification. So we're operating from that. And some would argue that the Supreme Court's decision in the affirmative action case really aligns with Title VII's objective to eliminate race as a consideration, while others would argue that it fails to consider historical inequities and things of that nature. When we look at the law and we look at Title VII as a standalone, regardless of your position on these things, what I can tell you is Title VII doesn't consider historical inequities. Title VII looks at and specifically provides race cannot be a consideration in an employment decision, as well as the other protected categories. Meaning, whether that's a Caucasian male who's, 30 years old, or an African-American female who's 60 years old. Race, disability, et cetera, cannot be a consideration in the hiring decision, in the promotion decision. Quotas have always been and continue to be unlawful under Title VII. So there are many factors that employers may consider when looking at employees. Employers may consider employees' backgrounds and experience. The first in the family to attend college. I think that's a really good example. Side note about me, neither one of my parents went to high school. And so I remember going into law school and looking around and seeing kids who, parents were lawyers and judges and doctors. And it was very intimidating. But I pushed through it and got to be where I am. And I think it not to say that I'm a brighter, smarter, better attorney in any way. In fact, I would consider most of my peers much smarter than I am. But it did, give me a different perspective. And I think I bring a different perspective to the practice of law than maybe somebody who's generationally back with many attorneys in their family. Whether, for better or worse. But that's what, it is a consideration. It's something you can look at. The ability to speak another language might be a factor that you need to consider. You can't consider whether an applicant is Latino, because that would be considering national origin, which is, would not be permitted. But you certainly consider whether an applicant can speak Spanish, because you have a need for Spanish-speaking employees. You can consider the adversity or hardship that an employee faced. Maybe, and again, you can't consider national origin, but you could consider, wow, this employee came over from Nigeria when they were 15 years old and worked night school as a single mom and put themselves through college. Those are factors you want to consider. That shows grit and determination. So there's a lot there that you can look at and consider that do not go explicitly to the race, the national origin, the gender of the applicant. And I would say that for those employers who are looking to broaden and diversify their workforce, look to where you are hiring from. What is your applicant pool? Where are you looking for your employees? Because if you're going to the same well, you're going to get the same water. And if you're going out and diversifying where you're looking for those employees, you're more likely to get more diverse employees, bringing more diversity to your workforce, different perspectives, differing voices and differing opinions. Sometimes we don't want to have different opinions in the workplace, but I think that generally speaking, different perspectives and different opinions bring vitality to the workplace. And so I think that the idea of diversity in the workplace is a great thing. And I think it brings a lot of vitality to workplaces. It's just how you go about it and ensuring that you are staying legal. So with that, employers should review hiring practices and your policies, review handbooks and equal employment opportunity statements. And I will tell you that the first thing when I'm in litigation, one of the first things that I'm being asked for is, show me the policies, show me the employee handbook. And so it's important, not only is that handbook a communication tool to your employees, it's going to be a communication tool in any litigation that you're in. And I hope for your sake, you're not going to find yourselves in litigation, although looking out here, I've walked with quite a few of you through litigation or litigation-akin matters. And so it happens. And so ensuring that your policies are up to date, is this the practice that we're currently using? And if it's not, update your policies to reflect your current practice. Because you're not going to want to be in a situation where you're trying to justify what's on paper and saying, well, no, that's not how we actually do it. Well, this is what your handbook says, or this is what the policy says. So making sure those are up to date and they reflect what you're actually doing. And then providing training to your managers. The managers are the folks who are managing your employees. They are also, and specifically your hiring managers, who are, interviewing and making hiring decisions, ensuring that they are aware of what they can and cannot ask, and what they can and cannot consider. There's a saying that goes, the road to hell is paved with good intentions. And we may have very well-intentioned managers who want to do the right thing, but do not know the limits of what they can do, do not know the boundaries of where they can go. And so making sure that you are putting in place proper training for those managers who are responsible for making those decisions. Transitioning. Well, any questions? Any questions about diversity, equity, and inclusion, Title VII, or anything right now? Yes? The question was, if somebody's out for more than 3 days, is it FMLA qualifying? And if it's related to a FMLA qualifying event, then generally it may be FMLA, they may be eligible for FMLA at that point, yes. Other questions right now? It's just me up here, so I'm going to be up here yammering for the next little bit, so feel free to jump in with any questions or stories you want to share. Yes?
How about a religious organization requiring a certain religious format?
Good question. Religious organizations requiring the employees to be a member of their faith or ascribe to certain faith values. So Title VII has a specific carve-out that provides that religious nonprofits are exempt from the religious component of Title VII, meaning that they can favor members of their own faith in hiring practices and promotion practices and things of that nature. Yes. Good question. Yes. Good question is, if you're a small business owner, and I know many of you are, and many of you don't have a dedicated HR staff, what are you supposed to do? You're running a business, so you're running accounts receivables and everything else going on, and then on top of it, you've got to manage hiring decisions. Is there a cheat sheet or something you can use? What do we do here? And it kind of comes back to some of it is generally common sense of you can't ask about disabilities, you shouldn't ask about race and things of that nature. But then again, if somebody has a story to tell, you want to hear it. So if somebody's telling you, my parents came over from Cuba when I was 7 years old, you want to hear about that story. And so it's allowing people to kind of talk a little bit about their stories. I don't know of a specific cheat sheet that, and this is a good idea for me maybe that I can, look at possibly some questions that you can and cannot ask and how you should avoid those. I mean, we often get into issues about disability and whether a person can perform the essential functions of the job, particularly for those folks with more physical, labor-intensive jobs, and whether they can, what kind of questions are we asking in that situation, knowing that we want to avoid workers' comp injuries, knowing that the individual needs to lift 50 pounds or more. In your situation with counseling and things of that nature, you're going to be looking at what's your background, what's your skill set. When you get into questions about kids, you said, can I ask, how old are your kids? I think that's a fair question, but it does raise the issue, and you can see this particularly in, big corporate world of, you have a 2-year-old and a 4-year-old, and you're probably going to have another one, and we're going to pass on this one. Well, that's illegal. And so making sure those questions don't, go in that direction where you're eliciting comments and statements from that employee that could be viewed as setting up a discriminatory motive. Other questions? Yes? The ADA overlay and FMLA? I will try. The ADA and the FMLA, this is a big, quandary. And you also get workers' comp mixed into it too sometimes. The FMLA provides that if you have more than 50 employees, you have to provide an employee who has a qualifying reason for leave, personal, sick, health reason, family member, immediate family member, childbirth, placement of a foster child, etc. You have to provide that employee with 12 weeks of protected leave, meaning they get leave for 12 weeks, either continuous or intermittent, depending on the nature of the circumstances. During that time, their job's protected. During that time, their benefits continue. Now, that, it's not an automatic, get out of jail free card, because if during that time there's a corporate restructuring or something of that nature, you may, look to, treat that employee as you would any other employee. The ADA, on the other side, applies to any employer with 15 or more employees, but let's just overlay that with the Pennsylvania Human Relations Act, which applies to more than 4 employees, and the Pennsylvania Human Relations Act mirrors the ADA. So let's just say for 4 more employees, you have these additional protections for individuals with disabilities, meaning that you can't discriminate against an employee with disabilities, and that you have to provide reasonable accommodations that would allow that employee to perform the essential functions of the job. There's this interplay between the two of them, because a lot of times what an employer will do is, particularly if an employee's out on FMLA leave, at the end of the 12 weeks, are they, able to return to work or not? And if they're not, do we get to terminate them? And the ADA says, or the FMLA, I'm sorry, says, you need to consult with the other statutes, because the other statutes may be relevant as well. And so a lot of times you're then having to provide additional accommodations to an employee, whether that's additional leave under the ADA or whether that is additional accommodations to allow them to return to work and perform the essential functions of the job. So it gets to be a really complicated mess sometimes. And I would say that when you get into a situation where you have those overlaps of ADA and FMLA and possibly workers' comp, that you're probably going to want to talk to somebody. I'd be happy to talk to you. I say somebody, you should talk to me. Because it does get pretty complicated, and particularly when you look at the ADA doesn't provide for specific resolution. It says, you need to engage in the interactive process with the employee. So you have to have this discussion with the employee and figure out, hey, what do you need? Okay, you need 5 minutes a day to take a break to go get some insulin because you're diabetic. We can accommodate that versus, you can't perform the essential function of lifting 50 pounds. We can't accommodate that because that's the essential function of the job. You're a warehouse picker, and this is what we need you to do. So you're constantly looking at this, and so it's all on a case-by-case basis, and it gets really complicated pretty quickly. And I've seen a lot of times, again, employers trying to do the right thing, but also recognizing, we have a business to run. We have operations. We have, quotas to meet. We have performance metrics to meet. We have clients to serve. And how do we do this in light of this? So keeping that in mind, that it just does get to be complicated pretty quickly. Salaried exempt employees. I'll move on, and then as you have more questions, please jump in. This is great. I much prefer a little bit of interaction here. Salaried exempt employees. Back in 2016, Obama had proposed some pretty significant jumps in the salary exemption. As you might be aware, most employees are going to be considered hourly. They get paid by the hour. They get paid $7.25 or more, and after 40 hours, they get paid time and a half. With the salaried exempt employee, you have to meet 2 criteria. One is you have to pass the duties test, which is you have to perform certain white-collar duties. And so for any kind of manual labor job, you're never going to get into an exempt category. There may be some manager situations where you would, but as a general rule, most manual labor jobs are not going to fall under the exemptions. But you have to meet those duties, administrative, supervisory, etc. And then there's also the salary test. And the salary test says you have to get paid a certain amount. And if you meet both of those, all you got to do is pay them that salary every week, as long as they're performing work during that week. Pay them the salary. They don't have to keep track of their time, and they get paid the same whether they work 20 hours that week or 80 hours that week. It doesn't matter. They just get paid the same. They don't get paid overtime. So there's some benefits to employers because employers now know that we have a consistent salary that we're going to be paying. It's easy to budget for. It's easier to, they're not tracking their time, so you're not having to worry about, tracking payroll. Employees kind of like it because, again, they also know this is what I'm going to get paid. Employees attach a certain idea to salaried exempt, thinking that it is a more preferential designation. And it may be in some people's minds, but keep in mind, if you're working 80 hours, you're still getting paid the same. You're not getting paid 40 hours of overtime. So I don't know. But I know a lot of employees really do cling to this idea of being exempt. So anyway, back in 2016, Obama proposed a major increase. It got struck down by the courts. We're seeing another proposed increase. There was an increase during the Trump administration that was upheld. I don't think there was a lot of challenges to it. I think he went through congressional authority on this, and that's where it kind of got tripped up under Obama because he had kind of done it on his own through an executive order, I believe, and they struck it down. And I think that that's where this is coming from, is from perhaps I think it's the Department of Labor. And so we're probably going to see challenges to this, given where the courts are at. I don't see that this is going to go forward, but if it does, there will be significant impacts for all of you because they're looking to propose the annual amount is going to go, it's currently $35,568, which if you think about it, $35,000 a year is not really a lot of money, particularly if you're asking somebody to work more than 40 hours a week. $35,000 doesn't go that far in today's economy. So, I think rightfully so, they're looking to increase it to $55,000. But I don't know that that's going to happen without some act of Congress, and I'm not going to go there. So we're just going to keep an eye on it. If something changes, I'll be sending out emails to update you if we do see changes, and keep an eye on it because it will dramatically impact you if the change does go through. How many of you use or have used temporary staffing agencies? All right, quite a number of you. How many of you have recently reviewed your staffing agency contract? One, good. The Department of Labor has increased the scrutiny of temporary staffing agency arrangements. And it has been assessing fines against the staffed employer versus the staffing agency. So this is really crucial because all of you who are using staffing agencies are now at risk for the Department of Labor coming to you and saying these independent contractors, as the staffing agencies like to portray them as, meaning they're an independent contractor, they're not an employee. So they're not going to get paid overtime because they're an independent contractor. They're not getting workers' compensation coverage. They're not getting unemployment compensation coverage. Nobody's taking out the FICA withholdings. They're just an independent contractor. Well, guess what? They're not. They don't work for themselves. When you look at what an independent contractor is, and you look at the Department of Labor's criteria of what defines an independent contractor, it is somebody who's in business for themselves, who stands to gain a profit or a loss through their activities. These are temporary employees who are relying on a staffing agency to place them with an employer to provide staffing services for a set period of time. They're not independent contractors. I've had multiple debates with staffing agencies over the years where they've sent my client a contract and it says they are an independent contractor. And I go back to them and say, they're not. Well, they are. How are they? Because they are. Huh? So we go through this, round and about, and I never get a satisfactory answer from them. because they're employees. They're somebody's employee. And as a result, the Department of Labor has started enforcing and going after the staffed employer, which has really big implications. And not only is it the Department of Labor, but it is also the IRS. It's also unemployment comp. Any number of these agencies will be looking at these arrangements and saying, well, you didn't withhold FICA withholdings, you owe back taxes. You didn't pay unemployment comp taxes for this employee, you owe unemployment comp. Oh, your employer fell down and broke his arm, there's no workers' comp coverage. Guess who's paying the bill out of pocket? You. Recently, the Department of Labor sued a healthcare management business for $19 million. $19 million, they sued the healthcare agency, the staffed entity. They didn't even name the staffing agency in the lawsuit. They don't even care about them. They went after the hospital or the system. So this is real deal stuff, and so what you need to be doing is looking at your contracts, and if, in fact, you are looking at those contracts and it does not specifically say, we cover the overtime, we cover the workers' comp, we withhold all the taxes, you need to find another staffing agency because you're putting the organization at risk. And I think significant risk, and not just from the DOL, but again, I think the biggest risk that I'm concerned about is the workers' comp risk. Because if somebody gets injured on the job, what are you going to do? How are you going to pay for that injury? It's going to be out of pocket more than likely, because your carrier is going to say, well, they're not under our policy. They're not listed on the names of employees that you've employed. We're not going to provide coverage, and leading to a lot of issues there. So that is a really big deal. And keeping in mind just what you need to be aware of when you're looking at your contracts. And if you have questions about your contracts, please reach out. Happy to look at them with you. Questions about independent contractors, temporary staffing agencies? Good. I think it's pretty clear. It's just and you can see why they want to do it, right? I mean, they don't have to pay workers' comp premium. They don't have to pay overtime. They just pay these people X number of dollars an hour. They get a nice premium on top of it. It's an easy way for these temp agencies to make a lot of money. And the folks I've been arguing with, they're not like little local mom and pop shops. They're like national organizations with general counsel. So I've been on the phone with their general counsel telling them, explain to me this. And they, so this is a lucrative business that they're in. It's a business model that they do not want to leave behind because they're making a lot of money. But now you as the employers are going to be in the crosshairs of litigation if the DOL, workers' comp, IRS come knocking. Moving on to a new piece of legislation, which is the Pregnant Workers Fairness Act. This is fairly straightforward. And I don't think that it comes with a lot of new ideas. It simply provides that covered employers need to provide reasonable accommodations to a worker's known limitations related to pregnancy, childbirth, or related medical conditions, unless the accommodation will cause an employer an undue hardship. So basically, it's taking the Americans with Disability standard and overlaying it on pregnancy. There had been some debate over the years as to whether, a normal, non-complicated pregnancy was a disability under the ADA, and courts had routinely said it's not. Only when there was a complication did it become a disability. So now what this just does is simply say, look, when you're dealing with a pregnant employee, you're going to treat them in a manner that is similar to all other employees. You're providing them with the same accommodations that you would to any other employee. A number of years ago, the Supreme Court had a decision in which a pregnant employee was denied certain accommodations that were being provided to an employee who was on workers' comp. Workers' comp employees got the light duty, but they said, hey, we don't provide that to pregnant employees. And the Supreme Court said, that's not okay. And they leveled that out and said, basically, all employees, all pregnant employees need to be given the same accommodations as other employees. So that was case law. This is statute. Congress, I think, came back and just said, we need to put this into statute here. So what do we look at here? Reasonable accommodations. Seems pretty simple. The ability to sit and drink water, closer parking, flexible hours, appropriately sized uniforms and safety apparel, additional break time to use the bathroom, eat, rest, leave or time off to recover from childbirth, and reassignment from strenuous activities and or activities that involve exposure to compounds not safe for pregnancy. Little caveat to that is the compounds not safe for pregnancy. Many years ago, I think this might go back 20 years, there was a Supreme Court case in which pregnant employee worked, I think, at a battery manufacturing plant. And the employer was very concerned that this employee was going to be exposed to certain unsafe chemicals and things, and told the employee they wanted to reassign the employee to a different part of the plant. And the employee refused. And the employer reassigned the employee anyway. Employee sued and won. So if the employee does not want the accommodation, you cannot force them to take the accommodation. So just keeping that in mind that, again, the adage of the road to hell is paved with good intentions. Just being sure that you are, being cognizant of what that employee wants, what that employee needs, what that employee is asking for. It's requiring, similarly to the ADA, a interactive process in which you're engaging with that employee and determining what that employee needs, what that employee needs to perform the essential functions of the job. Yes, please. So there's a number here, and I apologize, but I don't have that number off the top of my head. I want to say it's 10, but I'm not, don't quote me on that. But I will also say, again, you're getting into the Pennsylvania Human Relations Act, which tends to mirror the federal statutes. So the PHRA is a general broad statute and applies to employers with 4 or more employees. And I think you will see some of the case law developing around this because, ultimately this is going to be a gender-related issue. And they're providing, that equal employment opportunities regardless of gender. And I think that there's going to be an argument to be made that, if the pregnant employee is not being provided the accommodation, that it's due to gender discrimination. So there's a number of different factors that could go into that could, really bring it to basically all employers. But I think it's at 10, but don't quote me on that. Yes?
So how does that interplay with the FMLA if someone's not yet FMLA eligible? Would you be required to offer up to 12 weeks?
So if an employee, let me make sure I understand this correctly, is if an employee is not eligible for FMLA yet, so maybe they haven't worked the requisite number of hours, they haven't worked the full year, but they're, maybe will soon be eligible for FMLA, but they're now pregnant, what are you going to be required to provide? I think that's a really good question because it raises the issue of what's a reasonable accommodation? Is it reasonable for you to provide 12 weeks of leave to an FMLA qualifying employee? You can do that to an employee who's been with the company for a year and worked the 1250 hours in a given year. Why are you not able to provide that to an employee who may not be FMLA qualifying? Why can't you provide them with the 12 weeks since you're providing it to all others? And I think there's a good argument to say you may be required to provide that full amount of leave to an employee who's coming off of, who's given birth or otherwise has complications prior to birth. It does specifically reference time off to recover from childbirth. So I think we are going to be seeing this developing in case law. And I think the FMLA is a funny thing in that way, because when you're comparing it, a lot of times the comparison is, well, what's a reasonable accommodation? Is it an undue hardship on the employer? If it's an undue hardship on the employer does not have to provide that accommodation. Well, if you're already doing it for all these other employees and giving them 12 weeks off, why can't you do it for me, even though I'm not FMLA qualifying? And so I think it does raise an interesting question. Yes? 15 employees. Thank you. So as I said, accommodations provided to similarly situated employees. And again, when we use that word similarly situated, it is employees within a category of employees. And so you may be providing certain light duty accommodations to workers' comp employees that you need to provide to pregnant employees in that position, whereas another position that doesn't involve maybe manual labor or heavy lifting may have different accommodations that would be available. And again, one of those accommodations might be working from home. Well, if you are working in a warehouse, you can't do that remotely. So there's any number of possibilities there as to what those accommodations might be, but you're looking at that from a lens of similarly situated. And so because you've allowed certain office personnel to work from home, you have a warehouse employee who's pregnant, is requesting to work from home, you don't have to provide that accommodation because she's not similarly situated to your office employees, not in the same category. And the job can't be done remotely. All right. The National Labor Relations Board. Now, we've been hearing a lot about the NLRB recently. Maybe you've been aware of some strikes that have been going on. I've really enjoyed the return of late night talk shows. I missed those for a couple months. The NLRA, National Labor Relations Act, allows employers to unionize. Employees to unionize, sorry. But the act does not just apply to employees who are unionizing. The act applies broadly to all employees and employers. And the basic premise is that an employer cannot restrict employees from discussing the terms and conditions of the workplace. So employees can freely discuss the safety conditions of the workplace. They can discuss with each other how much they're getting paid, contrary to many employers' wishes that employees would not go around talking about how much they're getting paid with their coworkers. They can do this. You cannot prevent them from doing this. This has kind of been long-standing in terms of the employee's abilities to discuss the terms and conditions of the workplace. However, the NLRB recently issued a ruling which provided that an employer cannot have certain rules in place. One of those being, it cannot have a rule that promotes civility, and that it cannot prohibit insubordination. Now, I want to pause there for a second because it's important. I think those are very nuanced decisions by the NLRB, and what the NLRB is not saying is that an employer, or I should say what the NLRB is saying is an employer cannot require civility when an employee is coming to the manager and saying, there's a safety issue here and you need to fix it. An employer cannot require, or cannot prohibit insubordination when an employee is saying, I'm not working in this place when it's unsafe. I'm not working with Joe because he's been harassing me. I'm not going to continue to, expose myself to this air quality or whatever the case may be. There's no requirement in those situations that the employee has to, approach this in a civil manner or conform with the employer's directives. On the flip side, I'm not willing to accept, and I will go to the mat on this, that an employer cannot require an employee to be civil to one another in the workplace and have civilized, reasonable, respectful conversations. And if they can't, they need to shut their mouth and get back to work. It's just, that's how it is. I mean, and we've seen that lack of civility. We see it every day in Congress. We see it every day on the news programs. We see it, permeating every aspect of society. And I think that there's a point where we can dictate to our employees, we're going to treat each other with respect. And I don't think that the NLRB is in any way saying that you cannot continue to require employees to treat one another with respect. And again, I think that if employees are not able to do this if they're not able to talk about the Eagles and Jets game from last Sunday in a civil and respectful manner, then, we're not going to talk about sports. And certainly the same would go for politics. And again, with insubordination, the same way. If I tell you to do a job, the expectation is you're going to do the job. And you can make that requirement of an employee. So there's been a lot of discussion as to what this NLRB ruling provides. And I think that that's the interpretation I'm taking, and that's the interpretation I would fight for on this, is we still have the ability to require employees to follow directives. And if an employee says, nah, I'm not going to show up to work today, or nah, I'm not going to do that because I don't want to, then you can probably tell them, then you need to go home and, don't come back. Now, a couple other things, though, that come up in this is an employer cannot require the confidentiality of investigations or complaints. So a lot of times in your policies, and again, this is one where you're going to want to review your policies, is there's been a prohibition against an employee discussing a complaint, whether they're bringing that complaint or whether they are the subject of a complaint with other employees. Well, the NLRB says, look, this is the terms and conditions of the workplace. Jim's been harassed by Adam for the last 2 weeks, and Jim has a right to discuss this with his coworkers and say, have you been feeling this? We want there to be a limitation on that discussion because we want an open, we want a closed, sort of box that we can investigate as an employer as we're doing our due diligence as to what happened. And it's going to be a lot easier if not everybody's heard the same stories and all of a sudden they're repeating things that they may or may not know to be firsthand information. And so it's a lot easier for us as the employer to conduct an investigation when we have some limitation on conversations surrounding that investigation. But according to the NLRB, you cannot prohibit employees from having those discussions.
You would overlay that with HIPAA.
With HIPAA?
Yeah.
How so?
Why isn't John coming to work? Now, John's not coming to work because John came to you and said, I'm going into drug rehab for the next 6 weeks.
So that would be an ADA issue. The Americans with Disability Act provides for confidentiality as it relates to medical issues. And so an employer, there's no reason for an employer to disclose that information. And an employer is not required to disclose it. What this is saying is you can't prohibit employees from discussing internally investigations and things of that nature. Now, John may have a certain right to privacy because he's in rehab or he's undergoing treatments and things of that nature. However, I will say that generally speaking, contrary to a lot of opinion, HIPAA does not apply to most private employers. HIPAA would apply to medical providers, insurers, and those related entities. But when we look at a private employer, and we heard a lot about this with vaccines back over COVID, is employees say, well, you can't ask me that because it's against HIPAA. And it's like, it's actually not because we're not a covered entity. So the overlay with HIPAA probably would not be there, but the ADA provides similar protections that prohibit employers from disseminating private protected health information. So we still see that similar analogous protection there. But this would really be as to employees' discussions, and it's not saying that employers have to disseminate information. It's not saying that if a complaint comes in about harassment that an employer has to now say, we are providing an update to all staff as to the various complaints and things going on in the organization. It also says that the employer cannot restrict criticism, negative comments, and disparagement of the company's management, the products or services. It cannot restrict the use of social media comments to the media or government, and there's a limitation on recording meetings, use of cameras, and recording devices in the workplace. As to the recording devices, a lot of you, if you're in the healthcare industry, you certainly can restrict, the use of use of recording devices in the healthcare industry. If you're in the manufacturing business, you may have certain proprietary information you're going to restrict. There are any number of reasons why an employee cannot bring a recording device to the workplace. Again, I think what this is referencing is use of a recording device to document an unsafe working condition, things of that nature. This is not prohibiting an employer from maintaining the confidentiality of their trade secrets. Now, as to the non-disparagement provision, we're going to get to that in a second here because there are implications as to severance agreements that we need to consider when we're looking over and reviewing your current severance packages. I'll just point out again, review handbooks and policies. I've said that multiple times, but again, I think it's important, and I think given those rulings, you're going to want to look at your policies and practices, and I've had a couple employers recently send me over their handbooks and just say, hey, look, does this violate this? Because they had provisions in there that said, we expect employees and team members to engage with each other in a respectful manner. And it's like, no, absolutely, this is okay. But it's important to review those. Train your managers, understand what the rules do not prohibit. Employees are still at-will employees. They're subject to workplace rules and expectations. Employers have a right to expect employees to engage with coworkers in an acceptable manner. So your implications for severance agreements, and again, hopefully most of you have employees who have been with the organization for 20, 30 years, and sooner or later you're going to have a nice little afternoon gathering where you bring out the cake and everybody has a card they sign and you wish them well in retirement. That doesn't always happen, and sometimes it's a matter of terminating an employee or having an employee resign because you've kind of said, hey, you can either resign or you can be terminated. You restructure, you've downsized, you've phased out of a certain position. You're going to need to provide an employee with a severance agreement. Previously, when we had severance agreements, we had a agreement that said an employee, we're giving you $20,000 or $10,000 or whatever it is. We're giving you some money. We expect that when you leave the organization, you're not going to talk badly about us. A non-disparagement clause. You're going to refrain from discussing our internal operations with the media. You're not going to talk negatively about us in any way. And if you do, we're going to ask you to return that money, and we're going to cancel the severance agreement. Now the NLRB is saying you can't do that. You cannot prohibit an employee from again, talking openly and freely about the terms and conditions of the workplace. And part of what that would be talking negatively about the employer. So an employee now, who's terminated and gets a severance agreement, arguably can go to the media after they've got their severance check and say, they're a terrible company. They're absolutely terrible, and here's the reasons why. And there's not a thing you can do about it. The other provision that we often saw in the severance packages was a confidentiality. We are laying off 5 people. We don't want those 5 people to talk to each other about the terms of their severance because we're giving one person more than the other for reasons that we've determined are whatever. But this is what we're doing, and this is how we're doing it, and we don't want everybody to know that John's getting $10,000 more than everybody else. Again, the NLRB is saying, look, that's part of the terms and conditions of the workplace. They get to talk freely about that. So you can't prohibit an employee from discussing the terms of their severance. And so now all 5 of them can go out for lunch, say, what are you getting? I'm getting this, you're getting that. Whoa, I'm only getting, And then they come back to you and say, explain to me why I'm not getting as much as the other folks. So there's, a number of facets that go into that. But the big takeaway here is you cannot have non-disparagement clauses. You cannot have requirements of confidentiality. This is an NLRB ruling. This is not a court decision. We are likely going to see this challenged at some point. And so I may be back at you next year telling you something completely different. The NLRB changes with administration a lot of times. And so differing members will have differing viewpoints on things. So we've seen some fluctuation over the years. But as it stands now, this is something to keep in mind. So if you are routinely providing severance agreements to employees, you're going to want to keep that in mind. Yes? Is it always best practice to engage in legal counsel when you're giving somebody a severance? Yeah, I'm going to say yes. But, look, when you are giving somebody a severance agreement, in all seriousness, you are, basically providing them with a monetary amount that is being offered in exchange for them agreeing not to sue the company. And certainly, it's not rocket science, and so if you've done this a few times, you probably have a general sense of what you need to do. And I certainly don't want to overcomplicate your lives by needing to, run everything past an attorney. But I do think that, it is a significant matter, and one that you need to be sure is being done properly. There are often in severance agreements going to be differing considerations depending on the nature of the role. One of the things with that confidentiality provision that I neglected to mention was it does not remove an employer's ability to require an employee to maintain the confidentiality of trade secrets, of protected trade secrets and information of the company. And so you can still have that in your severance agreement, and there are going to be times where you're going to really want to make sure that's in there because it's your CFO who's leaving versus, the person who works in the warehouse who maybe doesn't have any access to confidential information. Sometimes you're going to want to have a one-page, very simple agreement because you're going to be giving that person a couple weeks. Is it worth, if you give somebody a 5-page, severance agreement for $1,000, they're going to think, what's up? What is all this paperwork for, this, versus, a more substantive severance package. And so sometimes you're tailoring that to meet, what's the position, what are the risk levels. So there's a lot of factors there that at least when I look at a severance agreement, I'm looking at. But certainly if you're doing these on a routine basis and you have some experience with them, then you probably have as good of a sense of, the risk level as I do. Yes? Sure. The NLRB ruling, is it something you have to follow now? Is it subject to change? And the answer is yes and yes. You have to follow it now because it's in effect. It's the NLRB's ruling. I am anticipating we're going to see court challenges to this. And given the Supreme Court's sort of dislike of the administrative state, you may see that the Supreme Court is going to come out against the NLRB on these things. saying, look, these are congressional actions that need to be taken, and we're not going to allow an administrative agency to take on essentially the legislative role of the highly dysfunctional Congress that we currently have. Sorry, I digress. But so you may see that ultimately the Supreme Court comes out and says, that's an issue for Congress, that's in Congress's purview to make those decisions, and not an administrative agency, because the Supreme Court really does not like administrative agencies, and they want to kind of do away with some of the administrative states' ability to make rulings. Speaking of administrative states, the Federal Trade Commission voted to ban non-compete agreements. Now, that has been delayed until April of 2024. It's likely to go into effect, resulting in many non-compete agreements not being enforceable. Again, subject to court challenges, so who knows where it'll go. How many, well, you don't have to raise your hands, but just think about it. Do you use a non-compete agreement? Is this something that is useful to you? When I talk about a non-compete agreement, though, I am specifically talking about an agreement that you will not compete against the business. When I look at a broad spectrum restrictive covenant, as I like to call them, there's three components to it. There is the non-compete, there is the non-solicitation, and there is a restriction on disclosure of confidential information. The non-compete is always optional. You don't have to have that as part of the agreement. And courts have always disfavored non-competes because you can't go and prohibit somebody from earning a living unless you can show a legitimate business necessity for doing so. Jimmy John's, the nice little sub shop, had a non-compete for its sandwich makers. And it provided that they were sandwich artists, they received certain training, and they couldn't go work for the Subway down the street, even though the Subway was going to pay them $1 more an hour, maybe 10 cents more an hour, who knows, in these jobs. That was challenged, and the court threw it out on its tail, as it should have, because there's no legitimate business necessity for Jimmy John's to have a non-compete with its sandwich makers. Versus, somebody who maybe you've invested in, they know how the business operates. They are fully poised to go out and start a competing business with you. There may be legitimate business reasons why you have a non-compete with an employee. But most employers, when they look at what they need from an employee who's departing, is leave our customer base alone. Don't touch our customer base for the next year. Don't loot our employees, and leave our confidential information alone, and we'll be fine. You want to go work for a competitor, that's okay. And I think that that's where courts have come out on this, and courts generally favor non-solicitation agreements because it's simply saying, leave our customers alone. We've introduced you as a salesperson to our entire customer base. You don't get to be here for a year and then decide you're going to go somewhere else and negotiate for a better offer because you've got a book of business that you can take with you of 50 of our best clients. That's not okay, and courts have routinely said those are very enforceable. So that distinction between a non-compete and a non-solicitation agreement is very, there's a very distinct difference there, and one in which I think when you're considering what you're using, I would say, the non-solicitation agreement is the one that's of most importance, unless there's specific reasons why you need to prohibit non-competition. And then you're also protecting your confidential information. You do not need an agreement to protect your confidential information. The Pennsylvania Uniform Trade Secrets Act provides for that protection already in common law, and it provides for criminal and civil penalties for somebody who acquires and disseminates confidential trade secrets, those trade secrets being information that's not readily accessed by the general population. So you have some protections already in the law, but I think it's always wise to have in a handbook, in an employment engagement contract or whatever it may be, hey, you're not going to take the following information, and particularly, customer lists, various, formation of customer identities and things of that nature that are confidential to the company, works in progress, pricing information, things of that nature that is highly confidential and could, really erode a competitive edge in the marketplace if a competitor were to receive those. So I want to leave us on some good news. And I think all in all, we've gotten back through the pandemic. People are coming back to work. We're seeing unemployment comp rates at the lowest in a long time. The economy seems to be getting there. I think we're at a good place. But I think this is a really encouraging trend I saw the other day when I was preparing for this. In 2012, the total number of EEOC charges, and an EEOC charges, I think you all know, is the administrative charge that somebody brings when they have a complaint under Title VII, the ADA, the Age Discrimination and Employment Act, those various statutes. They bring that to the administrative agency first before they file a federal lawsuit. You cannot go to federal court until you've gone through the administrative process. So that's the first step. So anyone who brings a claim under Title VII for race discrimination, gender discrimination, religious discrimination, disability discrimination under the ADA, age discrimination under the ADEA, it's a lot of acronyms. Anyone who brings that has to go through the EEOC. Well, in 2012, there were 99,412 total EEOC charges. We saw that start to decline, and then we saw a jump in 2016 to 91,503. Well, guess what was happening in 2016? The Me Too movement was sort of in full swing, and we could understand why there were a lot of EEOC charges at that point as people were beginning to really come forward with allegations of misconduct. But still, it was not as high as 2012. But then when we get to 2022, we're down to 73,485 EEOC charges. It's like a 25% decrease in EEOC charges over 10 years. I like to think that that's because employers continue to be responsive to employees. They continue to train employees. They continue to foster a workplace that is inclusive and respectful, and that employees are feeling engaged as a result, and employees are willing to bring complaints internally, and employers are proactively dealing with those, and we're not getting to litigation. So I think there's a lot of hopeful news there in that statistic. And so I leave you with that as sort of the final slide on this, is just we're in a good place. And I think you all as employers are doing a great job. I get to work with amazing employers every day, folks who really want to engage with their employees and really do the right thing by them, creating a work environment that gives people an opportunity. We're really fortunate in Lancaster County to have a culture here that really values work, but puts a premium on compensating people for their work and providing a workplace that's a good place to work, and a good place then to raise your family, and a good place to be. And it's great to be with all you all. So I'll open it up for some more questions if you have any. And understand if you got to head on down the road, that's fine too. But other questions or comments? Yes? that's a great question. Let me just rephrase that so that everybody can hear it. Is an employee on social media, there was a question asked, like one of these polls that people sometimes, send around. What do you not like about your job anymore? And the employee said, I don't like the customers. Oh, fantastic. And whether the NLRB's ruling, would protect that speech. And I think that it very well might. I think that that's a great, to keep in mind, it does, the NLRB is not saying, the employer doesn't get to engage with the employee about their comments. So, first of all, you're going to that employee and saying, hey, what's going on? Let's talk about what we can do here because we want to make sure you're feeling like you like your customers. But, when an employee is saying, I don't like my customers, can you take disciplinary action? What I'm seeing from the NLRB is that may be, tricky to do, but, I'd want to kind of flesh that out a little bit more. I know that a couple years ago, there was a case in the with the NLRB where an employee, I think it was a waitstaff, posted on social media that he hoped that the patrons at the restaurant ate broken glass and choked on it and died, or something to that effect. And he had sued, or the NLRB sued on his behalf, saying this is protected speech, or something to that effect. And the court said, no, it's not. You can't say that. That's outside the bounds of expectations. So there is an element of to what extent is this impacting business? To what extent is this impacting our ability to engage with our customers? But I think it would be, it's certainly in that gray area of what would be restricted. Yes?
I have another question along these lines, but it deals with the media or the government. Say you have a significant catastrophic event and your business is on fire. We currently have a policy that says these are the designated employees of the company that can make a statement to the media. Or you had a government agency that comes in unannounced, and we also have a policy who governs those type of activities. Is that now prohibited?
So the question being is, they have a policy in place, as to catastrophic, the building burned down, whatever the case may be. Who's talking to the media? Who's the designated responders to the media? Likewise, who's designated responders to, the OSHA guy who comes on site or the DOL auditor? What it's providing is the employer still has the right to say, these are the folks who are authorized to speak on behalf of the company. So there's a distinction there. That employee who's speaking on their own account and saying, well, I showed up to work and the building was on fire and this and that, and I knew that there was something wrong with that electrical system because, whatever. The NLRB is basically saying that employee has all the rights in the world to talk about that with the media, although that employee is not doing it as a designee of the company. And so, the company would have every right to come back and say, that person does not speak on behalf of company XYZ. Likewise, when engaging with government officials, anytime an auditor comes in, though, they have that ability to engage with your employees. And so, if somebody from the DOL comes into your office, they're going to start asking questions. They're going to want to sit down and talk with employees, and they're going to ask them, hey, how many hours are you working? Are you loading up the truck before you clock in or after you clock in? Are you getting paid for travel time? What are the policies? So your employees are going to have that ability. And your employees always have that ability to call OSHA up. And certainly I've seen that in recent weeks with a problem employee who was let go from a business and decided to make weekly OSHA complaints for a while just to be a pain. And I had to, kind of remind them that they have the ability to do this, and there's not a whole lot you can do other than remind the OSHA inspector that, this is a disgruntled employee, and, give it a couple weeks and you probably won't hear from them again. Any other questions before you get on with your day? Yes?
Going back to a quick thing that you said about salary and manual labor jobs, does that apply to all levels of construction workers, or is there a differentiation when it starts with salary exempt?
So salary exempt, the question being, how does that apply to construction workers? Am I correct? In most cases with construction, in the construction industry, most of your folks who are on the job site who may be engaging in manual labor are going to be hourly. So most of those will not meet the exemption because of the job duties. Because again, there's two classifications. Are you meeting the salary classification, and are you meeting the duties classification? And the duties is really tailored towards white collar, the white collar jobs, and so it's not generally going to apply to somebody who's on site versus, your folks in the office, the folks who are maybe doing the estimates, people who are in sales, things of that nature. Those people may qualify as salaried, but anybody who's has a tool belt on is probably not going to meet the duties test. Yes?
Does the non-disparagement clause you mentioned part of the severance thing, are we just not allowed to have those agreements at all with employees who leave
You mean
across the board?
a non-disparagement clause? So is our non-disparagement clause basically out? Yeah. They basically is the opinion of the NLRB that you cannot prohibit an employee from disparaging the company, which is across the board is speaking poorly about the company, saying that their graphic designs are terrible, or whatever the case of your industry might happen to be. My managers were awful. The roof always flew off. The shingles always came off a year after the fact, and, the computers always crashed 6 months after the install, all those kinds of things. The employee can free engage in that discussion, which is troublesome, particularly when you're providing an employee with severance. And, the idea being is we're parting ways, and we're not going to talk bad about you, and you don't talk bad about us. And now the employee can freely speak about the employer, but the employer still sort of, put in a tight bind because they don't want to get involved in, a defamation, slander sort of situation with the employee. So, all right. Well, I'll be around for a bit if anybody else wants to hit me up with any other questions. If not, thanks again for coming. It's been great having you all here. And really appreciate having this new spot. Oh, by the way, thanks to Mel and Allison in the back for helping facilitate all this. Super helpful. Appreciate you guys. Thanks, everybody. Have a great day.